May it please your ladyships and your lordships. May I correct something I said just before lunch? The Nottingham University study was only universities, my lord. I was wrong to say it was research institutions. I'd remembered the BBRSC figure of 33%, which is a research organisation from the judgment of Mr. Justice Floyd in Kelly. And that, if the court wants to identify where some of these figures came from in paragraph 240 at E422, which is tab 19, the hearing officer's decision again, volume 2, tab 19, internal 49. Paragraph 240, I think, was the paragraph where there were some rather different figures adverted to, and the figures at the bottom, a UK article in the Journal of Chartered Institute of Patent Attorneys referred to a fair rate being in practice between 1% and 3%. One paper referred to German rates in their well-established scheme, varying between 0.71% and 3.9%, with a mean of 1.6%, although in cross-examination he was taken to higher German figures of 7% and above and appeared to accept them. My lord, we have found, over the short adjournment, the article. We've got, I think, lots of copies. Is it convenient to give it to the court at the end of the afternoon?
I suspect we're not going to read it while we're listening to counsel.
Bit disappointed if you did, but the
you never know. We get up to all sorts of things.
It seems that the figures that were being referred to in that article are to do with a survey of European-wide practices, which is the subject matter of the article. I haven't digested it fully since it helpfully arrived at court, but it doesn't, we respectfully say, doesn't actually answer the relevance of the rates and the preference of Mr. Emmanuel's evidence that the hearing officer expressed. One of the interesting features of the case was Mr. Samuels mentions in his witness statement that he'd been working for the BBRSC itself at E1545, but didn't get round to mentioning that they'd adopted 33% as a public sector research institution, nor did, I think, Dr. Osborne find space for that. So the range of awards, of I should say, sharing percentage shares in academic institutions and research institutions. There is variation, there are some outliers. I think it's fair for me to direct the court's attention to two examples that Dr. Osborne chose to try to be fair, to give the court a feeling for the range of disagreement that was before the hearing officer. If the court looks briefly at E1428, which is in volume 6, tab 43, there are two relevant paragraphs, 196 and 197. And the HPA's scheme is very front-loaded for employee inventors because you get 30% of the first 0 to 40k, and then 20% up to 80k, 15% up to 120, 10% up to 240,000, and then diminishing 8%, 5%, 3%, and 2.5% over 1.2 million. That's one particular way a scheme has been set up. None of those schemes, of course, prevent an employee from claiming under Section 40 unless it's been set up by a collective agreement under the Act. But at 197, the other example that Dr. Osborne gave was the Medical Research Council, which allocates a share of its income from licensing and sale of intellectual property to the scientists and units that contribute to the IP, called the Award for Inventors Scheme, intended to encourage maximum involvement in the exploitation of research. Inventors receive 100% of the first £1,400 that an invention earns. A third of earnings up to 80,000 over the page at 1429, E1429. A quarter, 25% at 600,000, 20% at 1.5 million, and 15% up to 15 million, and 10% of earnings over 15 million. So my lord was right to ask me earlier whether there's a distinction between, and there is, but we can see from the BBRSC figure of 33% and the fact that these were Dr. Osborne's, in a sense, plum examples that he was using to reduce the percentage. The court will hopefully, your ladyships and your lordships will have a feel for what the range of dispute was, at least, within which the hearing officer came to make his decision. It is, of course, significant that in the paragraph in the respondent's written case, to which I've already referred the court, paragraph 77 at E-72, page 72 in the electronic bundle, which is in bundle 1, tab C. This is the passage in which Unilever asserts that the present state of the law, including the outcome in this case, shows a set of provisions working fairly and as intended, which does not require adjustment.
Sorry, what are you referring to?
It's
I wrote down the figure 72, but
Oh, I'm sorry.
You're in paragraph 79 of
79. It's 77 is the upshot is taken as a whole. The provisions are working well, and 79 is it's therefore submitted. Insofar as this case raises an issue fit for the attention of this court at all, it is in the awards. I hope the court appreciates I've not responded to a number of points made in the written case of the respondents, but insofar as fit for the court at all, in the awards both made and not made so far, one can see a set of provisions working fairly and as intended, which does not require adjustment. And that's prefaced by the fact that some companies on the previous page, E71, para 76, 4 lines up from the bottom on the right-hand side, third, in many cases, employers may have already provided compensation schemes by way of collective agreements with trade unions or otherwise. And my ladies, my lords, that's absolutely right. Lots of companies have, but Unilever hasn't, and that's why we're here. And it's to cater for the case in which the employer receives an outstanding benefit and does not have a scheme that these statutory provisions exist.
Could you make a claim even if there was a scheme?
I'm so sorry?
Could you make a claim even if there was a scheme?
Not if there's a collective agreement recognised by the Act, but if there's a scheme that's not such a scheme, you can say, well, they very generously gave me £28,000, but they got 20 million, and might I have some more?
Yes, because the fair share would take account of what you'd already got, obviously.
Exactly. And so one of the features in a lot of cases is people get perhaps a bonus or something referable to what they've done for the company and are still dissatisfied, as it's possible. But in this case, Professor Shanks got nothing. He actually became the youngest Fellow of the Royal Society, at which point he was promoted, but that was not referable to this invention at all. His salary went up slightly, and I think he got a better car as well. But in answer to my lady's question, yes, you can, if it's not one that's a collective agreement.
Yeah. It's interesting. I was looking at Mr. Emanuel's report, and the universities that he's looking at are mostly overseas, but there are two British ones, Imperial and Oxford. And the Oxford scheme is actually rather similar to Mr. Osborne's figures. Essentially, the research, it's on E1660, and the researcher is getting the lion's share of the first £72,000, but once you're above £720,000, he's getting 15.75%.
My lord, yes. So you get the first 63%.
Yeah.
You get 63% up to the first £72,000.
Yeah.
And then it goes down to 31.5, and then it's 15.75.
Yeah, and I think that's pretty much in line. I mean, it's the same order as the figures for the Medical Research Institute and the health research body that.
Yes, I think the HPA one is more generous at the beginning because it gives you 100% of the first 1,400.
Yes.
And it's less generous at the tail end,
Yeah.
which I think is why Dr. Osborne chose it.
Yeah.
But that's relating to the money raised annually, the HPA scheme.
Yes.
Whereas I think the Medical Research Council is a global figure.
Yes, I think
Not 100% sure about that, but
yes, I think they would probably have. They may have this. I think they may have the same effect because each year you're able to get what they've brought in. So I hope it may not make a difference.
Yes, the HPA scheme, 15% only goes up to £120,000.
Precisely.
Yes.
So
By the time you're over £1 million, you are seriously reduced. Yes, I see that.
Yeah. So on the assumption that's not a collective agreement, it might be a collective agreement, in which case everyone's agreed to opt out of the section, but if it's not, you can still bring a claim if they get 20 million. I think the backdrop to the Oxford University example at 1595 and elsewhere, and looking at a more international comparison just to calibrate, was that one did already have, of course, the Nottingham University study of 61 universities, which are listed on page 1647.
Ah, yes.
And in fact, Oxford, I think, does appear in that
Yep.
list. But it may be helpful for the court just to know.
Well, Oxford Brookes does, which is a.
University of Oxford on the right-hand column, my lord.
Ah, right. Fine, thank you.
So Cambridge, Imperial,
Yep.
Oxford, so forth. And lots of other good universities where similar sort of research is undertaken in particular areas.
Yeah, thank you.
So it was against the background of that I think a couple were picked out and then an international comparison made in order to give it a wider context. So my ladies, my lords, that I just wanted to correct that because I've been wrong to say it was public sector research funds as well. Other than just to list our key points, that's all I have to say to the court, unless there's anything upon which I can help further. My Lord Kitchen looks poised to answer one of those questions that seem friendly but are hard to answer.
The tax question.
Well, my Lord, we won on that in the Court of Appeal.
Yes.
So you're dealing with it in reply?
I was proposing to deal with it.
Very well.
And time value, we won on that.
The two of them, yes.
Yeah.
yeah, basically you're treating this as an appeal and a cross appeal.
I am.
Although technically it's not.
Technically it's not, but if it's convenient for the court, that's what we put in the timetable.
Well, that's what you put in the timetable, and we're not going to disagree.
I'm most grateful, my lady.
Thank you, Mr. Green. Ms. Campbell.
My ladies, my lords, may I address you in the following order? First, some general comments on the statutory provisions, then some general comments on the facts just to respond to some of the points that my learned friend has made, which are slightly tendentious as to his characterisation of the factual position, then address the two key points, outstanding benefit and the undertaking point as a matter of law and a matter of fact, and then make some general policy observations. I'll also then come on to deal with the tax and time value of money points, which are a separate issue. But I suspect that I'll need to address those tomorrow morning. Can I then start with some general observations on the statutory provisions? As you have all appreciated, this is an important set of provisions with potentially very wide application. And can I show you what I mean by that? If you take up volume 11A of the authorities, which has the statute in it, so in the electronic bundle E3035, just to orient those who are less familiar with this set of provisions in the context, what this provision applies to is inventions which are made by the employee inter alia in the course of their normal duties or in the course of duties that are falling outside their normal duties but are specifically assigned to them. That comes out of section 39 of the Act, because it's only if the invention belongs to the employer in the first place that these provisions have any purchase. There are, of course, situations where an employee will make an invention, but it is an invention that is outside his normal duties or outside duties that are assigned to him or her. And in those circumstances, the invention is not assigned, or patent rights are not assigned to the employer at all. And so this is a situation that only applies in circumstances where the starting point is that this is the employer's invention as a result of the employee doing that which he was contracted to do. And that is of significance for a number of reasons, including, in some senses, the quite interesting debate about university analogies, where, as my ladies and my lords may know, the historical position of academics in universities vis-à-vis their universities was not always the same as the position of employees in commercial undertakings. I'll come back to that point when we come on to the fair share points, but my ladies and my lord, it's important to understand that we're dealing with rights that, because they're what the company has asked the employee to do, are vested in the company. And my learned friend wants to say, and he does on various occasions, oh, this is something outside the remit of the work that was assigned to Professor Shanks. It was not in this case, and I'll come back to that in slightly greater detail. The important point, though, for you to understand is that the set of provisions is limited to that sort of situation. And that means that an employee who makes an invention that is genuinely outside the remit, that isn't something that he or she is employed to do, has complete rights as against that company to negotiate for terms if he or she wants to do so. And so if one is looking at a situation where an employee is doing something completely off his or her own bat, that there is freedom of contractual provision, subject to normal contractual requirements and subject to a statutory control in circumstances where the employee decides to assign the rights to the employer.
Paragraph B
Yes.
is dealing with the case where an invention would not reasonably be expected to result from the carrying out of duties. Does that cover the sort of situation of a director who has special
Yes, I'm sorry, I
responsibilities?
should have made
There's
clear.
a qualification to your submission.
Yes, there is a qualification. I'm dealing with the paradigm case, which is provided for in Section 39, subsection A. There is additionally a provision with respect to B, which might be thought to be a little bit like a fiduciary duty position, where a director or other senior employee has a special obligation to further the interests of the employer company, and in those circumstances also there is an assignment to the employer.
It's the distinction between what is done in normal duties and what is done within the duties of a fiduciary.
Indeed.
And whether or not an invention might reasonably be expected
Indeed.
to result.
There are requirements there, and there is case law that my Lord Kitchen has developed in a case called Life and Pinkava, from recollection, where these provisions are looked into in some detail. But that's the background.
And it's in B that one finds for the first time the expression the employer's undertaking.
Yes, indeed. And I'll come back to undertaking because my Lord has raised some points that we respectfully submit have clear answers on that, but it's convenient to deal with that under the separate head. Section 39 sub 2 makes the point that I made earlier, that any other invention shall be taken as belonging to the employee.
Yes, I mean, you used the expression assignment. There's no assignment.
No.
This is deemed to belong to.
This is deemed to belong to the employer as a result of the employee doing work that the employee is contracted to do for the employer. And it is not an unusual provision in the context of intellectual property rights, as those engaged in this will know. There are provisions in copyright law and so forth which vest rights in an employer if made in the course of employment and so forth. And that's the case with a range of rights. Section 40, though, provides an exceptional provision for compensation in respect of employees for certain inventions. And one of the important points to recognise about this section, and that is something that emerges from subsection 43, is that it is of very wide application in terms of the nature of the rights to which it applies. So section 43, subsection 4, makes it apply to any patent or other protection which vests as a result of those provisions, whether under the law of the United Kingdom or the law in force in any other country or under any treaty or international convention.
Well, that's not a surprise, is it, Mr.
It's not a surprise at all, and I'm not saying that it's surprising, but it is a question or issue that you ought to have in the back of your minds when thinking about the circumstances in which it is right for this sort of section to apply, and the bar that ought to be set for it applying, bearing in mind that
But the invention is made in the course of employment.
Indeed.
The patents are then filed, as one would expect, in every jurisdiction where it's economic to do so.
Indeed. But the consequence of that is that it applies to global rights. And it applies to global rights only in respect of UK employees. And that comes out of section 43, subsection 2, where the employee was mainly employed in the United Kingdom, obviously that applies in this case, or he was not mainly employed anywhere, or his place of employment could not be determined, but his employer had a place of business in the United Kingdom to which the employee was attached, whether or not he was also attached elsewhere.
Yeah, and that's not a surprise, is it?
It's not a surprise, and I'm not saying that any of this is a surprise, it's just a part of the context. One would expect that to be the case because this is a provision for, in a sense, English employees or employees of United Kingdom companies.
Well, and inventions made here.
Where the invention is made here. I'm sorry, I said English. I've made that
Yes.
error before, and I'm going to, I'm sure,
You tend to get pulled up on
pay
it,
for
especially in the current constitution.
Well, it's quite wrong. United Kingdom employees, and I apologise to all concerned.
Where do we find the motivation behind these provisions?
Yes.
This new domestic law, as the
Yes, you find the motivation behind the provisions taken as a whole in two ways. First of all, this new domestic law, namely the Patents Act 1977, was introduced in part to give effect to the European Patent Convention.
I know, but you don't. This isn't part of.
But this isn't part of the European
No,
Patent.
I know that. I was asking you where in the documents, the numerous documents.
I do
we
apologise.
find, whatever led to these.
I'm sorry, I mistook
Sorry,
my lady's question.
No, it was ambiguous.
The relevant parliamentary documents, if I may put it like this, the extracts from Hansard, referring to the motivation for this section, are in volume 12 of the authorities, and the Hansard extracts which are of greatest relevance to this set of provisions are to be found at page E3450. That's at tab 20 of volume 12.
But were there not reports or
Yes.
policy documents? Because we're much more interested in those usually than we are in whatever's said in Hansard.
Yes. These provisions were preceded by the Banks report, and that, I think, is not in the bundles, but we can provide that to you if you wish.
Certainly for my part, I'd welcome it, Mr. Alexander, the relevant bits of it anyway.
Yes.
I'm sure it's a very long document.
It is. We'll provide.
There will be
that.
some relevant things saying what the aim was and why.
Well, lady, the only thing you should know is the Banks report recommended against the provisions. So,
well, that's also interesting. Yes.
That's one of the reasons why this particular set of parliamentary materials is perhaps slightly more relevant in this context than that particular report.
Thank you.
But we'll certainly provide that to you.
There were no other reports after Banks and before the enactment of these provisions in this or the previous Act?
There was a working party report which no one has been able to find, as far as I'm aware.
It would be surprising if there were not, particularly if the Banks report had suggested there should not be a provision of this kind.
Yes, there was a working party report, and I don't think in the time that this case has been going that's been found. We'll renew attempts to locate that. I don't think the other side have found it either, and that is part of the reason why we've in a sense gone to the closest antecedent of the legislation to assist you on this, which is the parliamentary debates. The parliamentary debates, unfortunately, in some respects, but fortunately in others, are there in their entirety, so that you can read them in their entirety. But the bit that we particularly draw attention to as to the purpose of the section is to be found on the page that I have referred you to, which is in the speech of the Lord Chancellor.
Making sense of what a humdinger of a winner is.
Yes, exactly. That's the source of the humdinger of a winner, and it's also the source of the concept of an invention which may revolutionize a company or perhaps even a whole industry. And to some extent, that concept is picked up later on in, for example, the Kelly case. Now, while we're on parliamentary statutory materials, it is also right to know, and stop me if you're very well familiar with this, that the laws, of course, changed. The original provisions of the Act applied to the benefit derived from the patent.
Yes.
And then there was the change. In fact, some people have doubted whether it was ever intended to be quite as restrictive as to the patent in the first place, in the light of the title to the to Section 40, which refers to inventions rather than patents. But leave that point to one side. That has now been adjusted by the 2004 Act, which you have at tab 2 of volume 11A. I don't think we need to go to it. But on the question of material preceding that change, or more pertinently, non-change,
Well, you quoted quite a lot of it in your
we've
case.
quoted quite a lot of it, and just for your ladyship's reference, that is in volume 12, tab 21. And again, what we have done there is included the whole of the consultation, but the key parts relating to that are to be found at pages 3491, really starts at E3490 over to E3491. And that consultation is of some significance for this court, because specific consideration was given at that point to whether the test of outstanding benefit should be changed at all, whether the threshold was too high. And the consequence of that consultation was that all respondents, bar 2, agreed with the proposal that outstanding benefit should remain the threshold to decide when an employee is entitled to compensation from the employer. One respondent considered that outstanding was too high a threshold and suggested it be replaced by a term such as a special. Other individuals stressed that as outstanding benefit is too hard to establish, it would be better to repeal the section altogether, but all confirmed that the benefit must be significant, it must be real, not potential. So the consequence of that was that there was no change that was made, and in relation to the issue of the undertaking as well, just by reference specifically to some of the points raised, that was discussed to some degree, and again, there was no reason to amend the Act. You see that at paragraphs 101 to 104 on page E3491, but there was an amendment referred to at paragraph 105, which is the one that I've mentioned already in relation to the benefit from the invention. So our overall submission on that set of provisions is that they were intended to apply only in very exceptional cases for good reason, that was the original basis upon which they were introduced, and it was the basis upon which they were continued or confirmed in their existing form when the 2004 Act was made. Now, the second aspect of law is the proposition that the provisions are working well. It's been suggested that they aren't, and that the bar is too high, and that there are unreasonable obstacles placed in the way of employees. We respectfully say that that is not the case. What the tapestry of cases, there hasn't been a huge number of them, shows, is that actually these provisions are working well. What they show, and the Kelly case shows, is that if there is a genuinely outstanding benefit that employees provide, and they have made a significant contribution, done really superhuman work, that will be recognised by a substantial award, and that the courts are able to identify what the benefit is and to make awards in those circumstances. The earlier case law, which you may want to have in mind, I don't want to refer you to it specifically, but just so that you have it in mind, is actually relatively sparse, and one would expect it to be quite sparse, because if one thinks about these provisions only applying after 1978, there would be a period of time before cases of this kind came through. The first cases came through in the late 1980s and early 90s. GEC Avionics was one, and I'll just give you the reference to that because it's useful just to give a flavour of the way that these cases have been decided to see what has been going on. That's at 11A, tab 10. Just for your reference, that is E3126. It was the heads-up display, and there was an analysis of outstanding benefit to the employer, again done in the context of looking at what the patent had delivered in the context of the business of GEC in that context. GEC Avionics, and looking at the various other contracts that were of the kind that that company was entering into at that stage. You find that reference on page E3134 in that case. Then there was British Steel at 11A, tab 5. That was a valve for letting out molten metal, and the hearing officer was considering that approximately 5.4 million per annum over some years wasn't outstanding when compared with British Steel's undertaking. The case was, in a sense, decided in other respects, but it was a useful indication with respect to an industrial company.
Mr. Vivian in the GEC Avionics case used the expression something out of the ordinary.
Yes.
You've been using rather more demanding epithets in the course of your submissions to us.
Yes.
Exceptional. I mean, he's simply talking about out of the ordinary.
Yes, and you're right to pick up on that language, but in our submission, what he was seeking to do was reflect in that language something that was genuinely exceptional, because he was contrasting the situation, the factual situation with which he was faced, and saying, well, this is not out of the ordinary. It's not to say that what was being said was this is ordinary or not ordinary is the relevant test. So British Steel, again, I don't need to go to it, but just for your reference, that's E3052. And it was appropriate to look at the size and nature of the whole operation. Proven benefit there was a small percentage of the turnover and profit, and again, sums that were, in a sense, £1 million sums were not regarded as of outstanding benefit in that context. Similarly, Memco Med, that was the first case that went to the Patents Court, where Mr. Justice Aldous, we respectfully submit correctly, outlined the test and indicated that it was a high bar. That is at volume 11B of the authorities, so E3210. And the judge there said, in a sense, just reflecting the language of the statute, at E3221, that's 414 of the report, section requires the court to assess whether the benefit's outstanding, having regard, among other things, to the size and nature of the employer's undertaking. The court must look at the employer's undertaking, which may be the whole or division of the employer's business, and ascertain the benefit to the employer, taking into account the size and nature of the business. He went on to say at page 417 of the judgment, E3224, that the benefit was not outstanding. The finding effectively was that it was of importance, but not of significant, particularly significant importance. That the fact that the sales of detectors were increased when the particular model was introduced didn't mean that the monetary benefit was outstanding. And in our submission, effectively what you see is a set of claimants seeking to determine what the boundaries are of this jurisdiction, and the courts and Patent Office rightly saying, well, if the benefit that is provided by the patent is of the kind that a business of this kind would not find surprising, unusual, or out of the ordinary, that is not to be regarded as an outstanding benefit when one is applying the section. Then, of course, there's the contrast in Kelly. And in that case, what had happened, just to give you the reference, that's tab 12, so E3148. This was a situation where two scientists at Amersham International had synthesized a compound called P53, which then became a radioactive imaging agent, MyoView, and it was an absolutely stonking success for Amersham. It effectively transformed the company, on one view, saved it, and was one where the benefit in the context of the business, albeit hard to quantify, was very significant, both qualitatively and quantitatively. It formed a very substantial part of Amersham's profits in the relevant period, and was described as a blockbuster product. It was also one to which the employees had made an outstanding contribution. In fact, one of the employees went so far as to be the guinea pig for the trial of the test. And what the judge did was seek to evaluate what the benefit was. It was one of those situations that was actually quite hard to do that, because this was a situation before to which the 2004 Act didn't apply, so you couldn't look at the benefit from the invention, you were looking at the benefit from the patent, and the consequence of that was that an analysis needed to be done of what the benefit was. And having done the analysis, Mr. Justice Floyd tried to do a quantification. In our submission, reading between the lines, considering that the benefit was actually much more substantial financially even than he had identified, of £50 million, and regarding that as the rock bottom of the benefit that had been supplied to Amersham in that context. And this case is of assistance, we would submit, for a number of reasons. First of all, what it does is that it sets out in our submission correctly the approach to evaluating whether or not an invention is of outstanding benefit to the employer, having regard to the various factors. Second, it sets out a useful approach to considering fairness of share. And it is significant that, with the exception of the paragraph that was debated this morning about the university, the extent to which there were university parallels and the 33% reference, everyone has been regarding this as a sensible approach to application of the relevant statutory provisions. So in paragraph 60 of that judgment, which you find at page 381 of the report, or E3166. Mr. Justice Floyd, as he then was, draws the material together and sets out the framework for determining whether or not the benefit is outstanding. In so doing, he refers to the analysis of outstanding benefit that is undertaken between paragraphs 17 and 25 of the decision, which refers to the case law that I've mentioned to you, where what is said is that outstanding is not just a comparative term, goes further than that, implying a superlative. And we respectfully commend that approach, not least because it is an approach that, between the parties, is regarded as correct, and it's the approach that the hearing officer applied to this case.
In 60 subsection 4, he says outstanding means something special or out of the ordinary, more than substantial, significant or good. You go beyond that.
We don't go beyond that, but you do need to read that in the context of what has been said before in the paragraphs that I referred you to. So if you look at paragraph 17 to 25, he says that the concept of superlative is not one that means that the benefit could not be improved on in any way, in the sense that it is. But that doesn't cast doubt on the requirement that it should genuinely be outstanding.
May I just put another point to you on his Roman 4 in paragraph 60?
Yes.
He says the benefit must be something more than one would normally expect to arise from the duties for which the employee is paid. Do I understand your submission to be that one should look at it in terms of what one would normally expect to arise from a patent
Yes.
made or arising in or from the duties for which the employee is paid?
Yes, absolutely. Because if one's considering particularly an employee in industry who is in some senses employed to make patented inventions for his or her employer, the expectation from that is that the employee, and particularly the employee in a substantial undertaking, employed to do work for the whole undertaking, will be expected to deliver things that are of benefit for the undertaking. Certainly, that is the very job for which they are paid, is to deliver patents that are of benefit for the undertaking. And so, if you say, well, any employee who provides a patent that is of benefit to the undertaking, even if it is of, let us call it, significant benefit to the undertaking, is thereby automatically entitled to be treated as having provided an outstanding benefit to the undertaking. That would actually leach all meaning from the term outstanding. What you may as well do, and it is a matter for this court whether it should or should not, is to say, what you shouldn't do is to say, well, simply because an employee has delivered something that is financially remunerative, and in particular financially remunerative on a scale that for the employee would be regarded as very significant, they're entitled to say that that is outstanding. even in circumstances where that would not, from the perspective of the employer or the employer's undertaking, be regarded as even substantial, let alone outstanding. Now, this is an aspect that does engage the court's power, because where this court decides to put the bar for outstanding benefit is itself of huge potential importance. If what the court says is, well, if you take some quantitative value, let us take a value of £10 million. £10 million for everyone in this room is an enormous sum of money. It would be an outstanding benefit to have that delivered. But £10 million to a substantial pharmaceutical company, a substantial inter alia research-based multinational company, and particularly £10 million, if not delivered all in one shot, but where nothing was delivered for 10 years, and I'll come on to that, and then in dribs and drabs over a 20-year period, that was the return. If you then look back over that and say, well, the employee has delivered an outstanding benefit to the company on the basis that the money is big, if I may put it like that, that would set the bar in a place that it has never been set before in this country and would be contrary to the way in which we would respectfully submit both the statute is worded and Parliament intended. That's a rather long way of answering my Lord's question, because it answers a number of further questions as well down the road. But our respectful submission is that this is, in some sense, where the rubber hits the road on this sort of case. So, but what this case shows in our submission is that where there is a qualitatively transformative effect that a patent has on a business, where you can really say, okay, this really makes a huge difference to the business on any view, in those circumstances, then you're in the kind of territory where you may find something to be outstanding. You're not in that territory merely because, by reference to a private individual, the sums are large. And that is why Mr. Justice Floyd did the very careful analysis he did for what had been done and what the impact was on Amersham, its ability to incorporate another company within its remit, that not only did it help save the company, it also helped it grow in a very substantial way.
You're going to come back to the particular circumstances of this case in due course, although you're giving us a bit of a taster of, I think, where you're going.
Yes.
Because one of the points that's put against you, as I understand it, is, well, this is all very well, but one has to have regard here to the fact that the invention was made in an area and has an application for which Unilever didn't have any particular interest at the time. And so all that's been derived by Unilever is a royalty stream, which is in effect a bonus. And in that sense, it is not what Unilever would normally expect.
Well, one's got to be a little bit careful about that in a number of ways, and I'll come to this on the facts. First of all, it's not right to say without qualification this is an area in which Unilever was not interested. It's right to say that it wasn't particularly interested in this area, and you will see from the hearing office decision that he analysed this quite carefully. What happened actually with glucose testing was that the concept was in fact taken on by others, not by Professor Shanks, but others within Unilever. So in a sense, contradicting the idea that this was something there was no interest in at all, and in fact aspects of the technology were considered for other aspects of the business, because if one's dealing with a sampling aspect, that's usable for process control and so forth. I think it was applied to tomatoes, or it was tested for tomatoes at some point. So this is one of these situations where you can't say, well, simply because it was not a priority area for an undertaking, the fact that they managed 10 years later to derive some, in some sense, residual revenue from it in an area that they were themselves unable to exploit at an earlier stage, doesn't turn something that is not outstanding into something that is outstanding. One also has to be a little bit careful about interest. This was a case where on the facts, the patents were made available to many in the field at the outset. There was an option granted even to Ares Serono to take up these rights. They didn't take up these rights. They specifically rejected these rights and took up other rights. So this is not one of these situations where you can say, well, okay, this is the phrase is used that it's an orphan. In a way, that has some purchase, but it's not an orphan generally. It was not particularly a high priority for Unilever. And the consequence of that was actually they didn't receive a particularly significant benefit from it. This is one of these cases where, in some respects, all round, not an enormous amount was done or received.
Well, it may be that Unilever would have done nothing had they not had potential licensees approach them.
Yeah, absolutely, it may be. But my Lord has to be a little bit careful about this, because it wasn't just Unilever being approached by licensees. They did at an earlier stage, as you've seen recorded in the judgment, go out and make some efforts at least to get people interested in this patent through Professor Turner. As the hearing officer recorded, Unilever had a bit of a go, or Professor Turner had a bit of a go, and no one was interested. So this is not a case where, in that sense, it was just sort of lying on a shelf, and there was no effort put into it. But our submission in relation to that is that the way in which the case law has developed shows that this is a jurisdiction which, in what might be said to be deserving cases, the courts will recognise that there is an outstanding benefit and will provide compensation in respect of it. And the courts and tribunals have to draw lines in this context, and the manner in which the hearing officer made the evaluation in this case, we respectfully submit is not impeachable, and I'll come on and show you why directly.
Do we have any statistics? The number of claims that are made? Determined?
We don't have any statistics. There haven't been many that have come, the reported decisions, you've got all of them.
We very rarely had a case about statutory provisions of this potential importance, which have been so rarely before the courts.
But there may be reasons for that.
There may, yes.
First of all, people may have been doing deals. There may be schemes in place. Goodness knows what.
I think that's postulated in the IPO report.
That's what I was going to say.
Yeah.
But in terms of a full research landscape, that's not possible to say. So can I come on to discuss the facts? And I just want to make a few points just in response to what's been said by Mr. Green. Although it's no part of our case to make criticisms of Professor Shanks, it is right to say that his evidence was not accepted without qualification by the hearing officer. And you see that recorded in paragraph 5 of the decision. First of all, the hearing officer said that although he could generally trust his evidence, that was with a caveat that his recollection of events was 30 years ago, and his interpretation of the events may not be the whole story. There was one slightly puzzling aspect of his evidence where the hearing officer couldn't understand why he'd given an account of the FCFD prototypes, but not any account of the actual prototypes in issue. Taken in isolation, that actually is of very limited significance. But what it did is it cast some doubt on the approach that Professor Shanks was taking to his criticisms of Unilever for being very narrow in its approach. And you will have seen from the decision that is actually reflected in the factual findings, because whereas the case was essentially presented as a person going completely out on a limb, doing something that was quite different from that which Unilever was contemplating, the actual facts as they emerged in the hearing were much more nuanced than that. He was obviously employed by CRL, the service company in this context for the Unilever group, which was employing the Unilever's group's research staff. And the genesis of the invention was not one where he was completely forbidden from working in this area. To the contrary, if you look at the summary of the hearing officer's findings in paragraph 108, you will find a much more nuanced picture. And we respectfully submit that is justifiable, because if you think about the nature of the patent, it's not a patent that is a patent for glucose testing. It's a patent for undertaking, for a part of a sampling device. And although Professor Shanks was at some point keen that it should be applied in that area, it was something that was, seen from that perspective, squarely within the kind of thing that you would expect someone working on biosensors to come up with. Second point on the facts relates to the significance of the invention. Again, it is put forward that this was a revolution for the glucose testing market. It wasn't, and you need to, in my submission, understand a little bit about the context here. Professor Turner, a rather eminent expert, gave evidence in relation to this. He was cross-examined, and the hearing officer reached rather balanced conclusions, with having actually looked at the relevant documentation and gone through the history. And the conclusions were not those that were advanced by Professor Shanks, that this was a industry-changing technology. The conclusion was that it was a useful technology, but not one that seemed to be vital. And that was not, as it were, just the hearing officer saying that. The market was saying that as well. Although it is true that a number of the players took licenses under the patent, it is equally true to say that there was one very big player who didn't and did something else. And there was evidence before the hearing officer as to whether that would or would not have fallen within the scope of the patents. But that particular undertaking, from that undertaking, nothing was received at all, because they refused and indeed played hardball with respect to an attempt to license. So what we don't have is a situation where you've got a patent that is some kind of key. It's something where you can see that if a reasonable rate is provided for its use, you could see why undertakings might say, well, actually, I'd quite like to use that. But it's not one where, in a sense, Unilever would have been able to push its luck with respect to a better licensing program. There is a useful summary of the benefit obtained from the licenses in the confidential schedule to the decision. And if I can just make 2 or 3 points on that, that is volume 2 at tab 19, page E426. And I will just do that by reference to the little code that we've been using for confidentiality, if I may. I don't think I need to refer to any of these licensees by name. Just on confidentiality, the only reason that there is an issue here is because we're under confidentiality obligations, which we don't want to breach, but we don't need to refer to this in detail. There were the licensees who received license, who made payments, but they were not payments that were made all at once. The first payments started in the 1990s, and one point is of some significance on this aspect, which is that if you look at the licensee 6 down, where you have a rather small number, that was a licensee who'd actually taken a royalty-bearing license. And the significance of that is that this is not an easy industry to be in. This was a licensee where Unilever was in principle entitled to recover on a per-unit basis, at a particular point. What did that deliver? Very little.
Well, we can't infer much from that, can we, Mr. Alexander? We have no idea what the circumstances of this company's business were.
It may be. My point only is this, that criticisms have been made of Unilever's licensing approach, that they should have been approaching things in a more aggressive way, including before you. There was a mass of evidence relating to this before the hearing officer. The mass of evidence relating to the licensing approach was summarised in the skeleton arguments, and you can look at those if you want to. Unilever did their best against a headwind, a significant headwind, of challenges to the patents. So the evidence before the hearing officer was that not only were the licensing efforts by Unilever generally good, but that there was an unusual level of resistance put up by potential licensees to entering into those licenses, and that's recorded by the hearing officer in the judgment. This was not money that simply fell into Unilever's hands without it having to do anything itself.
Do you have a paragraph of the hearing officer's judgment that you're standing on?
Yes. Let me
not take you out of your sequence.
Let me come back to that. Just I want to check that reference. So there were difficulties. There was even material which we don't need to go to, where Unilever had gone out to persuade people to get licenses, and its own internal material, which was evaluating the validity of the patents, said actually we're not sure that really our position is as strong as we've represented to the field. The patents were not granted in Japan for a considerable period, and there was opposition in the United States as well. So our submission is that there were rights that were put into our hands that we needed to exercise our muscle to deliver the royalties in respect of. My Lord raised the point in relation to Mr. Justice Arnold's adjustment, and it's perhaps convenient to deal with that here. The most convenient reference to that, and it's actually referred to in Mr. Justice Arnold's decision, but I can give you the most convenient summary of that, is in...
I've got it, paragraph 22 of Mr. Justice Arnold.
It is, and I think you were asking for the backup of it, effectively. You'll find the best summary of the licensing material in our skeleton argument before the hearing officer, which has all of the references as well, which has some advantage, and refers to Mr. Emmanuel himself saying that Unilever had very significant negotiating clout. And the reference to that is in E656, that's bundle 3, tab 25. I'm sorry, I've quoted it slightly inaccurately. Mr. Emmanuel, so this was the expert on the other side, had formidable deal closing power. And that's the reference that Mr. Justice Arnold picked up. And he also said that they would have had greater credibility with licensees. And that reference, which refers to Mr. Emmanuel's evidence, which you also have in tabs 48 and 49, contains the complete references in relation to that.
Sorry, could you please give me the reference to that again?
I'm sorry, the reference to the relevant summary is paragraph 133 of our closing skeleton, which then gives the cross-references. It's E656. And while we're on that document, in case you are in any event, in any sense attracted by the submission that we were engaging in incompetent licensing with respect to one of the licensees, that was addressed in full by the hearing officer, and there is a mass of reference to that material in the annex about Unilever's licensing activities, which starts at E695 and goes on to E709. And so if you want the full gory detail of what Unilever had to do over a very lengthy period to secure these licenses, you will find it all set out there, including the pushback by the licensees, the references to the invalidity of the patents and the non-infringement and so forth. So, in all respectful submission, to put this case as though it was something that is just a kind of windfall for which we had to do absolutely nothing is not right. We had to do a considerable amount, and we had to do a considerable amount bearing in mind that we were a substantial company in a position to exercise our muscle in this way. And despite that, one might say, the benefits were spread over the life of the patent, depending on whether one takes tax into account, of the order of about £1 million a year. And we respectfully submit that if you were to hold that it was an outstanding benefit to deliver to a substantial undertaking benefits over the life of a patent that were about £1 million a year, that would set the bar for what was to be regarded as an outstanding benefit very low indeed, having regard to the nature and size of Unilever's undertaking. And what effectively that would be saying to the industry is actually really the only thing that counts here is the monetary return at the end of the day. If someone has invented something in the United Kingdom and it delivers that kind of return, and it delivers it in a way, particularly in a way that, in a way, is something as a result of not being able to use it in the business, then employees are entitled to recover. That would, we submit, send a troubling signal to industry in general, and not just large industry, small industry as well, because one would then be thinking, well, wait a minute, what happened in that case? Something that was actually a kind of invisible benefit to the company were entitled a claim to be made with respect to employee compensation. What is my position to be vis-à-vis my employee, where they have provided a benefit for an SME that is monetarily smaller but may be no more significant than the benefit in this case. The reference that my Lord Kitchen wanted was the hearing officer's decision, paragraph 137, where he said, Mr. Welsh said that his experience with these patents was that the strength and persistent continuing arguments about their validity was significantly higher than he had experienced on other patents that they were licensing or enforcing, and that's at E404.
The conclusions really are set out at 139 to 143, are they not?
Exactly.
And that includes the basis, I suspect, for Mr. Justice Arnold's finding about the licensees contacting Unilever.
My Lord is right. So those are points that we would respectfully invite you to think about with respect to the factual background. The hearing officer was able to make a nuanced evaluation, taking all of the facts into account, relating to the history and the commercial context. You have only seen a small fraction of the material that was before the hearing officer, and which, in our respectful submission, he analysed carefully. And we have made points in relation to appellate function that need to dwell on those. But this is a situation where, having done that, the hearing officer's decision, in our respectful submission, on the essentially multifactorial evaluation should be respected. It was a reasonable decision in the circumstances. It's true it didn't favour Mr. Shanks, Professor Shanks, but it was a perfectly proper, well evidentially founded decision. Can I then turn to the points on the undertaking? Now, in our submission, the approach that the hearing officer took and as confirmed by the judge in the Court of Appeal was entirely justifiable, both as a matter of law and as a matter of factual evaluation. First, as a matter of, perhaps it's useful just to have out what the hearing officer did. That's in volume 2, tab 19, and it starts at paragraph 191 down to 197. 196, we agree, is a very important paragraph in this context. So the way in which the particular corporate group was structured was that the researchers at the Central Research Centre were doing work that was going to be exploited by the group as a whole. And it is therefore not surprising that if one's thinking about the employer's undertaking, and even if one's thinking about it in a very narrow way of looking only at CRL as the employer, this was an employer whose job, one might say, was to supply benefits by way of inventions or developments to the whole of Unilever. So if one asks the question, well, even looked at very narrowly, was the benefit that was supplied by CRL an outstanding benefit, assuming that one deems the benefit to have been obtained by CRL by the deeming provisions that we have discussed? Was that outstanding, bearing in mind that the whole purpose of CRL was to deliver benefits to the whole group? Now, in putting a blinker on and saying, well, in making that evaluation, we have to ignore the fact that CRL was there to provide benefits to the whole group, and therefore need to some extent to evaluate what the extent of those benefits are to actually provide any context for the evaluation that the statute has required. If you ignore that context, that we would respectfully submit is entirely artificial, whether one approaches this matter looking at, as it were, the employer simply as the employer, or whether one's looking at the employer's undertaking in the way that the statute requires. Part of the reason for this is because Parliament has provided that in evaluating whether or not the benefit is outstanding, regard must be had to the size and nature of the employer's undertaking. It is, in our respectful submission, not just reasonable as a matter of common sense, but natural as a matter of language to look at the employer's undertaking if it is a essentially service company within a group as that company for the group. What you don't do is ignore the nature of CRL's undertaking, CRL's business, as an undertaking in that context. And in our respectful submission, it would not only create difficulties generally, in that what one would be doing is looking at, in a sense, an artificial corporate entity in the context of a group, which we respectfully submit cannot have been intended, particularly given the avoidance provisions, which are in a sense designed to avoid that problem. It would be not only artificial to look at it in that way, it would actually mean that one was potentially leaching the concept of undertaking, of being given effect to, regardless of the precise corporate nature of the employing company. The statute specifically draws a distinction, one might say, between the employer and the employer's undertaking. And the composite to which regard has to be had naturally imports that context in which the employer is operating and what the employer is actually doing. And that is why we respectfully submit that when Mr. Justice Arnold came to look at this, which you find in 16B of Volume 2, at paragraph 61 to 64.
Page, please.
I'm sorry, E346. E346. He held that the hearing officer's reasoning on this issue was unimpeachable. Indeed, he went further. The logic of the Court of Appeal's decision drives one inexorably to the conclusion that the hearing officer reached. As he pointed out, the effect of the Court of Appeal's decision is to equate the benefit of the Shanks patent to Professor Shanks' employer with the benefit received by Unilever Plc and Unilever NV. It must follow the relevant undertaking was Unilever Plc and Unilever NV. In this context, unless you do that, you do get into an artificial situation where, in a sense, the employer's business makes nothing. And the realist approach that was ultimately adopted before the Court of Appeal on the previous occasion means that proper sense can be given to the employer's undertaking. But even suppose that that is wrong, and one looks at the employer in a very narrow way, and one then asks the question, well, was the benefit outstanding, having regard to the size and nature of the employer's undertaking? I think you have my submission that you can't then rip that company out from its context of being something that was intended to deliver benefits more broadly. So whichever way you do it, whichever way you look at the position. In our respectful submission, the approach that was taken by the hearing officer, by the judge, and by the Court of Appeal was correct on that.
Does the former approach involve treating the words "the employer's undertaking" in section 40, subsection 1, differently from the identical words in section 39, 1b? No, it doesn't. Because if one asks the question let us say in a context of this kind, is there a special obligation to further the interests of the employer's undertaking? And the employer's undertaking is an undertaking that is designed to deliver research fruits to other parts of the business, and the benefit to that undertaking is to be measured by reference to whether or not it has actually done that, because that's its task. Then there is no distinction to be drawn. In our respectful submission, whether you look at this formally, if that's the right term, or purposively, if again that is the right term, you reach the same conclusion. I may be wrong, but it seemed to me that the formulation you've just used fitted your second category better than your first.
Yes, you may well be right about that. Yes.
But you say it makes no odds.
We say it makes no odds, yes, in this or any other like case.
Thank you.
In section 40, subsection 1, it talks about outstanding benefit to the employer,
Yes.
as opposed to the employer's undertaking. Are we to make anything of that?
Well, probably not. Because it doesn't actually matter on at least one of the arguments, or possibly two of my points, whether it is the employer formally or the employer's business.
It has to be outstanding benefit to the employer.
Absolutely.
But do you accept that the words "the employer" in 39 and 40 refer to the legal employer?
Yes, that's correct.
Yeah,
But what one can't ignore from that, or one can't remove from that equation, is what the employer is actually in the business of doing.
Oh, yes.
Yes.
And it is for that reason that we say that the approach that was taken below was entirely correct. Indeed, if one envisages taking a different approach, one would be then actually ignoring the fact that the employer's undertaking was an undertaking of being the company that employed the researchers for the Unilever Group.
Yes, but under your second approach, the relevant question, I think, would be how does this patent provided to the Unilever Group compare with other patents provided to the Unilever Group? In that context, you'd look at the section 41, subsection 2 deeming provision and compare like with like. I would have thought that would be a logical way to go about it.
Well, but if that is the case, then one has a very artificial impact of the deeming provision there, because what that then does is it means that you actually take the benefit that has not been provided by the employer at all, deem that to be provided to the employer, and then ignore the fact that the benefit has not been provided to the employer for the purpose of deciding whether or not the benefit is outstanding.
Well, I may have misexpressed it. It seemed in fairness to the employer, you would have to, in making an assessment, you would have to assume that all the patents they provided to the wider Unilever Group were as if they were provided to a third party.
Yes, you're right. And in fact, that, in some sense, reduces to the realist point, because what it does is it effectively deems everything to be provided in that way.
I mean, we need to bear in mind that what we're to have regard to, amongst other things, is not only the size, but also the nature of the employer's undertaking. And the nature of CRL's undertaking might be said to be the carrying out of research for the purposes of the Unilever Group.
Well, inter alia, it actually employs all UK staff. That was one of the purposes of it is that.
Yeah.
But you might say, well, yes, it is providing benefits to the Unilever Group.
I see. So it's what it says it is. It's a central services
Exactly. That's
company.
What it,
so it provides services to the Unilever
Exactly.
Group, including research services.
Exactly.
Yeah.
And that's why we say that there is an artifice in this, because it's a service company for the group. And if one then says, well, actually, what we are going to do is to ignore the fact that that service company for the group didn't receive any benefit at all, for the purpose of looking at whether the benefit is outstanding because of the deeming provisions. But on the other hand, what we're going to do is we're going to deem all of the benefit that has been obtained by the service company, by Unilever, to vest in the service company, notwithstanding the fact that it is, in a sense, an irrelevance. That would, in our respectful submission, be extraordinarily artificial, because what you would have is a situation where, notwithstanding the fact that it didn't make a difference, and the whole idea was that it shouldn't make a difference, you would have a situation where it made an enormous difference whether or not the employees were employed by a service company rather than by the undertaking that was actually receiving the benefit. And the deeming provision would not then just be an anti-avoidance provision, as the Court of Appeal has held. What it would be a provision that essentially said that any benefit that would be obtained by on this theory, any benefit obtained by the Unilever Group would be an outstanding benefit for CRL. The reason being that CRL is not there to make any money. It's providing services. And the consequence of that would be that Section 41 would have been turned on its head from being an anti-avoidance deeming provision into a provision that actually made it impossible for an employer to defend itself from a claim on this basis. It would be a kind of reverse avoidance position. It would actually create a position where the employee could avoid the effect of Section 40 of requiring the tribunal to have regard to the nature and size of the undertaking. And in our respectful submission, that would be an extraordinary construction of these statutory provisions.
Mr. Alexander, might it be said, well, just as it's wrong to look at CRL in isolation, it is also wrong to look at the whole Unilever Group, because what was done here has absolutely nothing to do with Viennetta ice cream and all the other activities. And so in considering what is meant by undertaking, one must bring a focus to the relevant parts of Unilever's business. And the relevant parts of Unilever's business may be said to be much smaller and not generally to involve the licensing of patent rights of this kind. And so also the amount that's committed by Unilever to research and development was in this rather narrower field considerably less, by reference to which it may be said this money is indeed very significant and outstanding.
Well, there are a number of difficulties in that approach. The first difficulty is that that's actually not right on the facts of this case, because essentially what one's looking at here is a situation where the research undertaking was providing benefits for the whole of the Unilever group. That was the actual factual finding that the hearing officer made. To then say, oh well, actually, what we need to now do is look at some other part of the group would fly against that fact. The second part, and it's important to remember this, is that these were benefits obtained by licensing. They weren't by the whole of the Unilever group. This was not a situation where there was an individual division that was exploiting the patents, where you could say, well, here is a subset of Unilever that it's right to look at this and it's right to ignore something else. This is a situation where it was, in a sense, Unilever and Unilever's muscle as a corporate whole, which enabled it to secure the relevant license fees as a corporate whole, because it was the assignee of the patents. So in our submission, to say, well, actually what one needs to do is to carve the entity up in a way that is contrary to the factual findings and contrary to the way in which the licensing actually went, we'd say that is itself artificial. And it may be that there are other cases in which the position is different, where you say, well, actually there is an identifiable division that can be one can put one's finger on, and that one ought to undertake the comparison in that respect. Here, there wasn't that. You have to really look at this by reference to the benefit that was acquired for Unilever as a whole. And indeed, one might say that the very fact that it is put by my learned friend as a windfall, we don't accept this, by the group as a whole, actually reinforces that. So this was a patent that was potentially applicable to a range of areas. It found licensing application in the particular areas. That doesn't mean that it was not a Unilever group asset, licensed and reasonably licensable as a Unilever group asset in that context.
Have we got findings that this particular invention was of relevance to the Unilever group more generally?
No, not that specific finding, because that was not the way in which the case was developed. But the point nonetheless remains that this was a patent that was licensed by the Unilever group as a whole.
That's true.
And treated in that way. And it's not surprising that that was the case, because it was the fruit of a research centre that was intended to provide benefits for the Unilever group as a whole. This is not a patent that is only of potential application in one particular area of Unilever's business, as I've said.
Subject to the deployment of the Unilever muscle to secure the royalty rates that were in fact achieved, that becomes dangerously close to the too big to pay argument.
No, it doesn't. It doesn't, because we say that if there was some, for two reasons. First, if there were to be a credible entity by reference to which a comparison could be made, as in the Kelly case, Amersham, which then became part of GE, that comparison can properly be made. But secondly, and importantly, one also needs to think about this in the context of substantial undertakings. So if you consider that this was a patent which delivered, one might say, only £1 million a year over its life, you would have to get down to quite a small undertaking in this context before that kind of benefit was going to be regarded as a significant benefit in this kind of context. Because our point, which we illustrated, was that if you look at this in the context of both Unilever and indeed substantial companies generally, this is not a significant benefit. So in our submission, either way you look at it, that's an answer to the point that it provides an answer to the point that there isn't a problem here with too big to pay. And in fact, Kelly rather suggests that there isn't that problem, because there you have a proposition where you can see that there is a very significant benefit on the undertaking. Amersham pays.
But as you've submitted, as I understand you, this invention was not in fact used by Unilever. It wasn't deployed by Unilever across its business. Is that not right?
It wasn't. You're right. There was some work done for deployment of aspect of it in different aspects of its business,
And that cost about £1.5 million.
Exactly.
Pounds.
Exactly, and it wasn't ultimately turned into a profitable invention. And indeed, this is one of those situations where if it had been deployed in other parts of the Unilever's business, it may have been for process control and so forth, where there weren't direct sales.
The application for which it did find a commercial use was in providing what might be described as the base technology for these glucose testing kits, which ordinary individuals could use. It wasn't essential, but it was certainly convenient for companies in that field to use this technology for that purpose. And that was an application that Unilever were not themselves interested in.
My lord is right, yes. But that doesn't in any way mean that the too big to pay argument is our point. It's not. Our point is that if one is evaluating whether or not a benefit is outstanding, one needs to look at the context in which that benefit was delivered and what actually it provided to the undertaking in question.
Can I at risk of detaining you for a few moments longer, can I just take you back to section 40?
Yes.
And try to pin down precisely who's the employer in that section, with a view to going to paragraph 64 of Mr. Justice Arnold, because I think you were, and something you've just said suggests that this is maybe so as well, I think you were commending to us the way that Mr.
Yes.
Justice Arnold analysed things. He ends up with, it must follow that the relevant undertaking was Unilever. But if you go back to section 40, I think that you were accepting that the employer in that section was CRL.
Yes, that's right. The employer was CRL.
So
the employer's undertaking was Unilever, Unilever NV, and PLC.
Well, it has to be CRL's undertaking. Surely the way that you can get to Unilever is to say that because the nature of what CRL is doing is a service industry to Unilever, therefore you can take account of Unilever's position, but it doesn't make Unilever the undertaking.
No, that's quite right. Yes, that's quite right.
So it's not quite right. The last sentence in 64 is not right.
Well, it's right in this sense that if you're making an evaluation for the purposes of, if you want to take account of what the size and nature was of the employer's undertaking, which was the purpose of doing this evaluation, for that purpose we submit that he was right to say that the employer's undertaking for that purpose is, you evaluate that by reference to Unilever Plc and NV.
Oh, yes, evaluate by reference to, but it isn't actually it.
My lady is right in that sense, yes. So I've dealt with undertaking, and I've dealt really with a significant number of points on outstanding benefit, subject to any further queries on that aspect. Can I then come on to some of the points in response to what my learned friend has said? And it's actually convenient to do that by reference to the approach that the hearing officer took. So volume 2 again, tab 19. if we go to the critical paragraphs, first of all, this is E415. There was no dispute that the approach that was adopted in paragraphs 198 to 200 was the right approach, and that the hearing officer directed himself by reference to the right principles. Indeed, that was the basis upon which the appeal was advanced to the Court of Appeal, was that the hearing officer had got it right in terms of the way that he'd set out the law. The hearing officer then, in our respectful submission, whichever way you approach the employer's undertaking, rightly looked at the benefit in the light of Unilever's profits and turnover. He referred in paragraph 202, again correctly, to the evidence of Mr. Samuel that a sum of that kind was not regarded as significant, although, of course, it's right to say that if one thinks about a loss of £15 million all in one go, that might be a significant sum, but I've made my point that this was not money that was all made all in one go. He addressed there the point on too big to pay, and suggested that this would make it impossible for people to claim against undertakings such as Unilever. We don't accept that. It would certainly be possible to make a claim against substantial companies in circumstances where what had actually been done did have a substantial quantitative and qualitative impact on those companies. If one thinks about the context of blockbuster drugs, which are sometimes referred to, everyone can tell when a drug is a blockbuster, and it's no answer to a claim for an employee compensation in such a context. Say, well, actually, it's relatively modest because you've got all these other drugs. What one's talking about in that context is, in the case of some of the most valuable pharmaceuticals, products that return several £billion a year worldwide. And in those circumstances, one can recognise that an income stream in the billions would have a significant impact. The second point, and it is an important one that the hearing officer drew attention to in the context of this, is at paragraph 207. The too big to pay point ignores one very important factor in this context, which is leverage. Not leverage in the sense that my learned friend would have it, of corporate leverage to secure deals, but the individual employee having leverage to turn that which is their invention into value for the company. One of the difficulties with these sections overall, as you will have appreciated, is that they might be said to be extraordinarily individualistically based, in that what they do is they say, well, let us identify the particular named inventors on the patent and benefit those named inventors. That's the way that the statute goes. But one of the reasons why it is so important to take into account the size and nature of the undertaking is because an inventor working in a company where sales are ordinarily very substantial is able to translate those by virtue of being in that company into sales or whatever it may be. That is very substantial. And it is not the inventor who is doing that. It is others. It may be thousands or hundreds of thousands of people working in that company who are translating that benefit, and including, one might say, consumers and so forth. The consequence of that is that if you, again, leach out the size and nature of the employer's undertaking from that evaluation. You say, well, just because they're big, they shouldn't pay. You also leach out the very important factor, which is that the expectation is that an employee in a smaller company will be in a less good position to make substantial returns for the employer than an employee in a larger undertaking.
In general, that may be so, but that has no application in the context of this invention, does it?
Well, it does, because we respectfully submit that for a number of reasons that's relevant. First of all, because there is, in a sense, a clout of Unilever making those benefits. And secondly, one might say, actually, what is going on here is that one is looking at lump sum fees in relation to products that are produced by third parties, which may be sold in significant quantities. An employer in that kind of context would be naturally expected to make larger sums with respect to both patented and non-patented products than an employer in another context. Now, that may or may not be true in any given case, and that will be something to evaluate. But what one can't do is, in our submission, is simply ignore the fact that we've got a context of an employee working in a company where he or she is able to act with others in order to produce the benefit. And that is why, in our submission, the hearing officer was right to say that it was totally logical that a given monetary benefit might be outstanding for a small entity but not for a larger one. That is a corollary of that analysis.
The only way you've harnessed the might of Unilever in the context of this invention is in securing the royalty rates. You haven't harnessed the ability of Unilever to manufacture at scale, market at scale, and so forth.
No, but that is because of the nature of the exploitation here. And it might be said, well, if one thinks about not only this context, but let us say small biotech undertakings who make inventions with a view to licensing them on, who may not have clout in that sense, but where an employee may deliver something that is of some value to that undertaking. It's no answer to that to say, well, actually, the reason to refuse them is because they're working in this particular context, any more than it's a reason to say on the other side that it's a reason to reward them because they're working in a context where more generally inventions and products of this kind are more naturally to be expected to deliver significant benefits. Otherwise, you get a somewhat artificial divide between licensed inventions and ones that are exploited within the business. And you have a slightly odd situation, which would, in our respectful submission, have an undesirable effect, not only in these industries, but more broadly, where paradoxically, it's better to produce for your employer an invention that can't be used by your employer because, well, it has numerous advantages. One, you can say, oh, well, there were no costs in relation to that. That's very advantageous. The other thing that's wonderful about it is you can say, oh, well, there's a very clearly identifiable benefit. It's much easier to identify that benefit there, that licensing stream, than it was, for example, in Kelly, where both employer and employee had to do quite a lot of work to work out what the ultimate benefit was. What you don't want to do is to have a divide between the two. And there's no warrant for that. And if I may respectfully say so, it is, in a sense, a factor to be taken into account if one's looking at having regard to the size and nature of the employer's undertaking, which the hearing officer did take into account in this kind of context. And so it's not an answer in my submission to the point that we put against the case, to say, oh, well, but in this case the benefit was obtained by licensing, because that only pushes the problem one step further down. It doesn't actually solve it. The benefit in relation to the patents in general, we respectfully submit that the hearing officer was entitled to take that matter into account to the extent that he did. He didn't find it of great assistance. The difficulty with this point, and by way of answer to my friend's case, is that if one is going to turn these sorts of cases into ones where one doesn't just look at the benefit from the patent or from the invention, but one's always got to do a comparative exercise with respect to other patents or patents in general, one is going to have a situation where one risks doing not only a Kelly exercise, which was a very substantial exercise for the patent in issue, but a Kelly exercise for lots of other patents in order to come up with the comparative figures. That would be very undesirable. And in our respectful submission, contrary to the approach which says actually this ought to be a situation where you recognise the benefit rather straightforwardly. The benefit in the context of Unilever's licensing activities, well, in some senses, following the point that I made earlier, yes, this is unusual, but the only reason that it's unusual is because this is not the kind of thing that Unilever was wanting to do. So again, if you say, well, the reason that it's outstanding is because it stands out, because it's not something that, because it's a third tier down, and so Unilever was not at licensing generally, that actually again turns the purpose on its head. What it then advantages is licensing that a company does of residual rights over and above benefits derived from its core business. And what you would then get is a situation where, in a sense, employee compensation was available in relation to situations of residual right licensing, but not others. And that would be a very odd situation. Benefit in view of Unilever's patent activities. Again, that's an exercise. It's the same problem.
I'm sorry, Mr. Alexander, we've got to 4 o'clock.
Oh, I'm sorry.
It's a precious time.
In that case,
You've got plenty of time.
I'll draw a close. Yeah. There's not much more on this tomorrow morning, and then I will go right into tax and fair share and the other points.
Very well. We'll look forward to hearing from you tomorrow morning. Court will now adjourn.